webinar. It is about 5 minutes till 11, so we'll get started in 5 minutes. Thank you. This is Richard Sheinis at Hall Booth. It's just a few minutes until 11 o'clock, so we'll give it a few more minutes before we get started. Thanks. Good morning, everyone. This is Richard Sheinis at Hall Booth Smith, and along with my colleague Chase Langhorne, we appreciate you joining us this morning for what I'll call a quick webinar. I know as we've all been working remotely that webinars seem to be the popular item. So we're just going to talk for 30 minutes today instead of a usual 1 hour. We'll have some question time as well if people have questions, but hope everyone is staying healthy, enjoying some of the positive aspects of working remotely, and let's get going. So the two topics we have for today are talking about the revisions to the CCPA regulations. This is not intended as a general overview of CCPA preparation or the entire act or regulations. It's really to address what's new since we have had now 3 versions of the regulations that have come out. And my colleague Chase Langhorne will talk about the CCPA regulation revisions. I will go ahead and get us started with talking about some of the effects of COVID-19 on data privacy. One thing to note is that I will not be talking about security issues. There's been a lot out there about working securely in a remote environment. So this is going to focus on the privacy aspects of COVID-19. So starting off here at home, just a quick mention about CCPA. I'm not going to go into the revisions, but the question is, will CCPA be enforced as of July 1 when it is scheduled for enforcement to go into effect? In the middle of March, a consortium of 35 advertising groups, which grew to 60, sent a letter to the California Attorney General saying, there's kind of a lot going on right now. How about delaying enforcement instead of July 1? How about January of 2021? The response from the Attorney General was a fairly curt, we're going forward on July 1. My sense is that this is likely to change between now and July 1. I think this response, and I've pretty much said this, I did a post last week on our firm COVID-19 blog and our data privacy and security blog, essentially stating how ridiculous this position is. While companies are struggling to stay afloat, millions on unemployment, salaries being slashed, revenues reduced to a trickle, to expect companies to continue to prepare when we still don't even have the final version of the regulations that we can rely on is ridiculous. But for the time being, that's what they're saying. We will see if we get a change. Staying at home, talking about HIPAA for anyone involved in the medical field, anyone that might be a covered entity or a business associate. There has been a relaxing of enforcement. They've not changed the rules. They've not said that certain HIPAA rules or regs don't apply. But dealing with telemedicine, HHS has recognized that people, both patients and medical providers, are going to engage in methods of communication that might not be compliant with HIPAA. Normally, we're used to communications having to be secure. We don't just send a text message with medical information, things like that. But recognizing that these are difficult times and that communications, whether it be through SMS, text, Skype, other methods of communication that might not all meet the requirements of HIPAA, might not have business associate agreements with vendors that might provide the communication channels, that there is enforcement discretion. I guess by using the word discretion, they're saying if someone did something really bad, there might still be some enforcement, but otherwise they recognize that telemedicine, when it's rushed into play like it is here, with COVID-19, there is some relaxation. Moving abroad a little bit, but of course we know that GDPR does apply in the United States as well to certain companies that are doing business in the European Union. They issued a statement, that the European Data Protection Board did, that is, middle of last month, essentially saying that there are already provisions that allow for employers and public health authorities to process information. Article 6 deals with some of the provisions as far as legal basis for processing personal data. Of course, we have consent, but another basis is that the processing is necessary to protect the vital interests of the data subjects, or the processing is necessary for the performance of tasks in the public interests. In many cases, both of those will fit for the processing / sharing of medical information. And since medical information does fall within the special category, or as we call sensitive data, that's Article 9. And again, one of the bases for processing sensitive data is if it's for a substantial public interest. So there might be situations where the sharing and processing of data is not only for the benefit of the particular data subject, but also, excuse me, for the benefit of the public at large, if you will. We'll talk in a few slides about the geolocation sharing that is going on. A lot of the questioning that comes up with COVID-19 information deals with the personal information of employees, and many of the EU countries have issued their own statements. I'm not going to go through them all, but they do. I'll say the general trend is making sure that there is some, I'll call it relaxing or understanding of the information, the health information of employees when it is for the betterment of the workplace, if it is a business where there are people in the workplace as opposed to everyone working remotely. As far as mobile location data, again, I will talk about this in a little bit, and there are European countries that are using anonymized mobile location data. But the statement from the European Data Protection Board states that the mobile location data is really governed by the e-privacy directive, and it goes into that a little bit. Let me just mention a few of the European countries that have issued some statements. The CNIL from France gives us a do's and don'ts, such as a business cannot do mandatory readings of employee body temperature or have them fill out specific questionnaires, but a business can raise general awareness and certainly to promote remote working. From the Netherlands, they've acknowledged that when there are questions from the AP, the authority, businesses will be given more time to reply. Location data can be used only if there is a statutory regulation allowing it. They do not go into whether they have such statutory regulations currently in the Netherlands, but they are also working on a plan to relax the rules for accessing medical files of corona patients, which normally would only be with a patient's consent. The ICO in the UK, which is typically pretty forthcoming with guidance and information, has also issued a statement They understand when there's a data access request that can be made under GDPR, it might take a little bit of extra time to do that. The usual maintaining security for remote working, and although there should not be a detailed questionnaire of employees, it is okay to ask employees if they're experiencing COVID-19 symptoms, and if there is an employee that has tested positive for COVID-19, it is okay to generally inform other people in the workplace, if they still have people coming to the workplace, that there is someone who has tested positive, but of course they caution against using names or other descriptive information that would identify a particular person. So this is for places, you know, a grocery store that might still be open, that this type of information might be useful. Jumping down to South America, Brazil has their general law for protection of personal data. LGPD stands for the Portuguese name for this particular general law. I am not going to try to pronounce what LGPD stands for, but this has not gone all the way through the Brazilian legislature, approved by the Senate, but still waiting for other approval. But it looks like LGPD will be put off until January of 2021, with enforcement not until August 2021. The Brazilian law is very, very, very similar, as much of a copycat really as possible, to GDPR. Something else that is going on is the use of mobile data. Google came out just last week on April 3rd, publishing what they're calling their COVID-19 Community Mobility Reports. And I'm actually going to jump to the next slide quickly and then come back to this maybe. But this is just an example that they've published of a community mobility report. So what it's intended to do is, number one, use just aggregated anonymized data, not individual data. Google has a very thorough algorithm, they tell us, that they go through to make sure data is adequately anonymized. And then they use this data to chart movement trends over time. So they don't give strict numbers. So for instance, you can see in the slide, it might show grocery and pharmacy for a particular location, and this could go down to the county level. But the grocery and pharmacy, the trend is down 16%. So they don't say how many people is in 16%, but just the trend over time, down 16%. So it's high levels of categories. They won't say a specific grocery store, the trend is up or down, or the percent. Again, it will be more general like it is here: grocery, pharmacy, retail, might be parks, things of that nature. This is really going on across the board, though. This is not just Google that is putting this out there for really anyone who wants it. The state of Kansas, I read, is using a social distancing dashboard from a company called Unicast to show on a county level generally whether people are staying at home or if they're congregating in particular areas. In fact, the $2 trillion stimulus package that was just passed by our government gives $500 million to CDC to launch a new surveillance and data collection system to monitor the spread of COVID-19. According to Reuters, telecom companies in Europe are sharing anonymized location data with health authorities in Italy, Germany, and Austria. The same thing is going on in South Korea. Taiwan is pretty strict. I'm not sure how I would like this, but what they are doing is they're collecting data to create geofencing, and they're using this location tracking to ensure people who are supposed to be quarantined do in fact stay in their home. And if the tracking shows that a person is leaving their home or they turn off their smartphone, that supposedly the police will show up at their door within 15 minutes. Now that's what I've read, so that kind of gets into the scary part, but that's what they're doing. Sounds a little police state-ish, but in these circumstances, that's what Taiwan is doing. The question I have is will this be the new normal? Once COVID-19 either goes away or is, I'll use the words, under control, what about the secondary uses of this type of information for marketing, determining business locations, things of that nature? It reminds me of several years ago, we did not have to pay to bring luggage or check luggage on a plane, but there was a time when oil prices went through the roof. And in order to add compensation, that's when the airline started charging for checking bags and has moved into other things. So once the oil prices came back down, the baggage fees did not go away. It became the new normal. So I question whether this type of data and the ease of sharing the anonymized data, even though it makes people wonder about, is this, the big brother state watching over us and watching where we go? Will this be the new normal? So with that, I am going to now go ahead and turn this over to my colleague, send it over to him. And Chase, why don't you take it from here and review the CCPA regulation revision.
Thanks, Rich, and good morning, everybody. And as Rich said, we'll kind of go through some of these new revisions that the AG has put out for the CCPA regulations. Kind of as we move into the first slide here, kind of show the timeline of how we got here. Late last year in October, we got the first draft of these regulations. And then in February, we got our first set of revisions. And then most recently, in March, we got the second set of revisions. And I note there that each of these revisions had a public comment period for the AG. And in this particular situation, the comment period for these last sets of revisions ended on March 27th. So kind of jumping right in, I've kind of categorized these, not exactly how the categories used in the regulations themselves, but grouped them to where they seem to make sense. First up, under mobile devices, we've got some clarity on when you might need a just-in-time notice. And the way the AG has written this one is that when personal information is collected that is not reasonably expected from a consumer. And the example the regulations gave was that if you were a consumer and downloaded a flashlight application on your device, and that flashlight application was also collecting your geolocation data, that is unexpected. You would need to be given a just-in-time notice. And the way we'll see those, I anticipate, is similar to the way we see them now. When you open an app, maybe for the first time, or if they've added a feature, it asks you if you would be willing to share your location data, just like it would if you wanted to access pictures through the application. Things like that would qualify as a just-in-time notice. And then these last two here are just some clarifications on where certain information would be able to be provided in a mobile application. If you would like to, as a consumer, to opt out of having your data sold, that link can be provided in the settings menu of the application, just like your general privacy policy can be provided in the settings menu of your application. Kind of next general category here is your employee data collection practices. Now this is still the same under CCPA, where employee personal information is not subject to CCPA, at least until 2021. We still have not gotten any direction on whether that will stay the case. But specifically during this time, this year where employee information is not subject to CCPA, you do still have to provide information to the employee in your privacy policy of what types of personal information you're collecting. The previous revision of the regulations noted that you needed to provide a link to your privacy policy when you're collecting personal information from employees or job applicants, and they have removed that requirement. So if you were to collect job applications online, in the previous set of revisions, you needed to have a link to your privacy policy on that page, the application page. Now you do not have to provide a link to the privacy policy on that page, but you do still need to have that information in your privacy policy. And the second one right here is that they removed the do not sell button graphic. You still need to have a button that would allow a consumer to easily opt out of the sale of their personal information, but now it is left up to the business to design that button. It was the first round of revisions where the AG provided a button. It looked kind of like a slider where if you were going to agree to sell your data, it would slide with a green check, and if you wanted to opt out of the sale of your data, you would click it, it would slide over, and there would be a red X. And for whatever reason in this last set of revisions, the AG has removed that example. So again, you still need the button, but it's up to the business to design what that looks like. Moving on to the privacy policy requirements themselves. So the big one here, which is kind of a lot to unpack, so I'll hit the high points, is it revised the description of providing your sources of where you collect personal information and the purpose of collecting personal information. The way the previous revisions to the regulations were written is you had to lay out very specifically the source and also the purpose for collecting personal information linked to the type of personal information. What we were seeing was a lot of businesses were even employing the use of charts in their privacy policy that would have one column with the type of personal information being collected, second column would have the source, and the third column would have the purpose for collecting the personal information. They've now reworded it to more align with privacy policy statutes that we've seen across the US and even internationally, that you just need to have the types of a category that lists all the types of personal information you collect, a category with all the different sources where you collect it from, and a category with all the different reasons. It doesn't make you be so granular as the way that the regulations were written. Next, under the privacy policy requirements is that if you're a business that has actual knowledge, and actual knowledge was the term they used in this revision, that your business is selling the personal information of minors under the age of 16, you have to explicitly lay out the opt-in process for how you collect consent from either the guardian of the minor or the minor, depending on their age. But the privacy policy needs to lay out exactly how you obtain that opt-in consent. And the third major piece under privacy policy requirements is that under CCPA, you're allowed to, as a consumer, appoint an authorized agent to make requests on your behalf. The previous revisions to the regulations noted that you need to explain how someone could appoint an authorized agent. They've revised that to say that you need to provide provide instructions is the term they use, but the practical matter of that is that you need to lay out exactly the steps that a consumer would go through to appoint an authorized agent to make a request on behalf of the consumer. So nothing incredibly onerous there. It's just things that you need to make sure are in your privacy policy. Moving on here to requests, and specifically the request to know and the request to delete under CCPA. I'll start with how the revisions have changed how you would accept a request. The regulations have added a provision that say that online businesses only need an email address to accept requests. and that's an online business that only interacts with their customers via the internet. So previously, there was the need to have a toll-free phone number for all businesses subject to CCPA to accept these requests. So if you're online only, now you only have to provide an email address to accept these requests. The revisions also removed the requirement to have an interactive web form. Previously, the revisions required that you have at least 2 mechanisms to accept requests, one being a toll-free phone number and one being an interactive web form. They have removed the requirement that that second mechanism be an interactive web form. So you still need to have your toll-free phone number, unless you operate online only, but still have your toll-free phone number, but you aren't required to have an interactive web form. So what you could do instead is you could have an email address where folks are sending requests, and whether you have a form or not is up to you, but you're not required anymore to have that interactive web form. And third, under the accepting requests revisions, is that it removed the requirement for 2-step verification when you accept a request to delete. Previously, the revision had said that when you receive a request to delete from a consumer, you then had to take the affirmative step to reach out to that consumer with an, "Are you sure? Is this really what you want to do? Please confirm this is what you want to do." That second step verification has been removed. So again, you can still do that, but the requirement has been removed. And now moving over to the changes in how you might respond to a request. We got some clarification on how many days and whether they are business days or calendar days, which is really helpful. This first bullet, confirmation, as we all know under CCPA, when you receive a request, you have to send out a confirmation to that consumer saying, "Hey, we received your request and we're working on it." The regulations previously said that confirmation had to be sent in 10 days. That has been extended to 10 business days. 10 days was a little short, we thought, so 10 business days, 2 weeks is much more palatable. The response timeline in general to respond to a request, this just confirmed what we were pretty sure we already knew, is that 45 days meant 45 calendar days. So just some clarification there. We also got a new provision that explained how, if you're going to verify someone's ID as required under CCPA, so someone has made their request, you need to verify that the person who made the request has the legal authority to do so and that it's being done so correctly. If you attempt to verify this consumer's identity and they do not respond within 45 calendar days, then you do not have to respond to their request. This still doesn't fix the underlying issue that we were seeing, that if the consumer were to respond on the 44th day, you would then only have 1 day to respond to their overall request. The clock starts when you receive the request and not when the consumer's ID is verified. So hopefully we'll get a little more clarity as this moves on and maybe some adjustments to allow for that type of situation. Something that we already knew, you can't disclose certain sensitive data points, social security number, driver's license. So somebody asks what data that you are holding about the consumer, you don't want to send back their driver's license number, social security number. Just note that that's what you have, but don't list any social security numbers or driver's licenses. Requests are limited to personal information collected in the last 12 months. That tracks with CCPA. So if somebody makes a request, you only have to look back 12 months to respond to their request. In this remove deletion method requirement, CCPA requires that you send a correspondence confirming that you have complied with a consumer's request to delete. And previously, that confirmation needed to list exactly how you deleted that information. You do not have to do that anymore. It just needs to say, "I have deleted your information." And then this last one is going to be interesting for businesses that sell personal information, is that if a business sells personal information and you receive a request to delete from a consumer, and you have determined that you are not going to comply with that request to delete, if you're a business selling personal information, you need to take the affirmative step to then reach out to that consumer and explain, we're not going to comply with your request to delete, but would you like to opt out of the sale of your data? So you're required to take that affirmative step to ask if they would like to opt out. Moving on here to the last couple that I'll hit quickly. As far as a request to opt out of the sale of personal information, the timeline to comply with those was extended with the clarification that it's 15 business days and not just 15 calendar days. Record keeping, this was something that we were advising folks we talked to anyway, but now there's an affirmative requirement too that you need to keep consumer requests that you complied with and also ones that you did not comply with for 24 months. And then the last piece is a little bit of a CYA, is that if you receive a request from someone claiming to be an authorized agent on behalf of a consumer, you now have the explicit right to reach out to the consumer to confirm that this authorized agent is in fact reaching out on your behalf. So kind of a lot to pack in there. And I think that covers the high points. And again, after this, feel free to reach out if anything comes to mind. And kind of as we're wrapping up here, just wanted to kind of put a little plug out there for 2 newsletters that Rich and I put together. Rich handles the Data Protection Weekly there that you can see on the left, kind of just snippets of current events. And then on the right, we do a weekly newsletter. I mean, a monthly, sorry, this one's monthly newsletter that has more of a deep dive on certain types of content. And kind of something else that I forgot that I wanted to mention real quick is New York Shield Act that we wanted to talk about, because that's kind of fallen, I don't want to say to the wayside, but I think it has been a little bit overarched by the COVID-19 world. And that went into effect on March 21st of this year. And as of now, no reprieve from the Attorney General on enforcement of that. It's going to happen on time, March 21st. And so you need to have your information in order for New York Shield Act as well. And with that, I will open it up to any questions. All right, with that, I think we'll wrap it up and let everybody get back to their day. So what we will do after this, for anybody who wants to take a second look or wants to pass it along to a friend, we will have the recording of this webinar posted. I'm pretty sure it will be posted to our YouTube channel, the Hall Booth Smith YouTube channel, but we will send out a link to all the attendees on this call so that you have it and can share it as you see fit. And I guess with that, we will wrap it up, and everyone have a great rest of their day. Thank you.